Hi everyone, I am Advocate Aashna Singh working as a legal associate with NRI Legal Services. India is currently a hotspot for attracting investors and enterprises owing to a favorable business environment and the ease of doing business. India, as we all know, is at the stage to utilize its productivity given its huge population and the majority of whom are in their youth. For the foreign investors who wants to invest their hard-earned money for a small, medium or large enterprises, this video is going to be of immense help. Today's video is to enlighten the investors abroad about setting up of a legal entity in India. I will be sharing with you very important information regarding this subject, so you must watch this video till end. To begin with, the very first question which comes to or bothers our mind is that what is a legal entity? Well, in a layman language, a legal entity is a setup for running a business. Then, how the business operations can be carried out in India? Well, the same can be carried out by establishing a company. There are three types of companies, namely public limited company, private limited company, and a limited liability partnership. Depending upon the type and requirement of the business, one can decide which company is to be established. Now, let me brief you about these three companies. At first, what is a private limited company? It is a company which is owned by non-government organizations or relatively small number of shareholders or members of the company. A private limited company usually does not offer its shares at trade in the stock market. A public limited company is strictly regulated and is required to publish its true financial health to its shareholders. Then, what is a limited liability partnership? Well, a limited liability partnership is an alternate corporate business form that gives the benefit of limited liability of a company and flexibility of a partnership. It is a separate legal entity and is liable to the full extent as to its assets, but the liability of the partners is limited to their agreed contribution in the LLP. Now, I will throw some light upon the basic requirements of setting up of a legal entity in India. To name a few are share capital, board of directors, number of members, time schedule, etc. To begin with, a minimum authorized share capital for a private limited company is 1 lakh rupees, and when we talk about public limited company, the share capital depends upon the need of the business. However, the minimum authorized and subscribed share capital required for the formation of public limited company is 5 lakh rupees, and in case of an LLP, the minimum capital required is 1 lakh rupees. Further, the members in each legal entity varies. When it comes to the formation of a public limited company, a minimum of 7 members are mandatory, whereas in case of a private limited company, it is 2 members, and in case of LLP, it is 2 partners required for its formation. Moving on to the board of directors. The board of directors play a very vital role in the establishment of the company. In case of a public limited company, a minimum of 3 directors are required, and in case of a private limited company, it is 2 directors. Please note that it is mandatory that at least 1 director shall be an Indian resident. Time schedule for the completion of a setting up of a company depends upon the availability of the signed documents. However, the time for a private limited company is 30 working days, and in case of an LLP, it is 20 working days. I would also like to explain you here that in order to carry out business activities in India, it is not mandatory for an NRI or a foreigner to establish a company. The business activities can be carried out by establishing an office, which can be in the form of a branch office, a liaison office, or a project office. A branch office is established by a company engaged in trading and manufacturing. The role of such offices is very limited and it cannot undertake any activities which includes manufacturing. The branch office can only undertake activities as approved by the Reserve Bank of India. Some of the approved activities are import and export, technical and financial collaborations, professional and consultancy services. Then, moving on to the license office. A license office is a common practice for foreign companies seeking to enter the Indian market. The role of such office is to collect information regarding the possible Indian markets and to provide the information regarding its company and the products to the prospective Indian customers. Such an office cannot undertake any commercial activities and must only use remittances as provided by the parent company to maintain itself. Finally, a project office. A project office is an office which is established by a parent company to oversee, facilitate, and maintain or to execute any activity related to a particular project. Here, a question arises as to how the investment can be made in order to establish a company or an office in India. Well, there are two routes, that is automatic route or the government approval route. In the former, no specific approvals are required, whereas in the latter, as the name suggests, specific approvals are required. The choice of investment route depends upon the nature of the business activity and the economic sector where the proposed investment occurs. Now, moving on to the procedure of establishing a separate legal entity. The formation of the business and the running of the business in India is subject to approvals of the Reserve Bank of India and the Government of Indian policies. The procedure commonly involves as follows. Firstly, obtaining the Director Identification Number, that is DIN, or Designated Partners Identification Number in case of LLP. Secondly, obtaining a digital signature certificate. Please note that it is mandatory for all the directors of the company to obtain the same. Thirdly, primary chartered accounts documents, that is articles of association or memorandum of association, which are to be drafted conforming to the provisions of Companies Act 2013. Such documents are to be submitted to the Registrar of Companies at the time of incorporation. Next, for the purpose of applying for incorporation, we have an integrated form that is submitted to the Registrar of Companies. It is used for the allotment of DIN, reservation of a name, incorporation of a new company, and obtaining a certificate of incorporation. Lastly, applying to the authorized dealer bank as approved by the RBI with copy of necessary documents, that is certificate of incorporation, banker's report from the country of origin, audited balance sheets of the applicant for the last 3 years, and the list goes on. Further, we have a few more of the registrations which are required, that is PAN, that is permanent account number for the legal entity. Then we have TAN, that is tax deduction and collection account number for the entity. Then we have GST, that is goods and services tax number. And finally we have IEC, which stands for Importer Exporter Code Certificate. Please note that these all are mandatory registrations and are required as per the nature of the business, and they are always used in various business communications and transactions. Also here, let me highlight you with some of the other statutory compliances such as audit by chartered accountant, tax audits, GST audits, IT returns, filing of quarterly TDS returns, and conducting board meetings if the legal entity is other than a branch office, a liaison office, or a project office. To conclude, as it can be seen that formation of the legal entity involves a lot of legal complications and legal intricacies, so it is always advisable that a legal advice should be taken before investing in India. We hope that you find this video informative and productive. In case of any query, drop us your comment below, or you can email us at query@nrilegalservices.com. Please subscribe to our channels for future updates. Thank you.